Welcome to What to Do When, a podcast from real lawyers with real perspective, where we explore a variety of legal issues and scenarios. Each week, we focus on a new topic and discuss what to do when and if any of these legal scenarios ever happen to you or a loved one. With over 40 years of combined legal experience, our hosts offer their unique perspectives and insights on a range of real-life legal situations.
Hi, and welcome back to a podcast, What to Do When, a dummy's guide to the legal verse. I'm Jackie Critzer, this is Scott Cardani, and we're at Critzer Cardani here in Richmond, Virginia.
What's on the docket for today, Jackie?
Post-decree or post-order enforcement.
So what to do when you have an order and you need to enforce it?
Yes.
Okay. Well, what are we talking about here?
Well, so we talk a lot about getting an order for custody, visitation, child support, spousal support, maybe an equitable distribution award where one spouse owes the other X number of dollars from the retirement or from the IRA or from the investment account, whatever the case may be. Maybe a spouse has been ordered to sell a piece of real estate. Okay. And it's in the order, which is fine. But what do you do when when the other person doesn't follow the order? Or what might happen to you if you don't follow the order?
First thing is know your order. So many people think they know their order and don't. Coming to an attorney and reading that order and making sure you're understanding what that order says to do. And like Jackie says, maybe it's saying can sell a piece of property versus shall. And there's just so many different language pieces that can be in there. We usually see this in custody and visitation cases where father's supposed to return the child at 5 p.m. Or a support case where the father or mother was supposed to pay $300 a month and has an arrearage of $15,000 and haven't done that, hasn't paid any of that, and how to get that in court.
But you need to know what the order is requiring of yourself, of course, and also the other parent.
I had a case one time, I'll never forget it. The parents had early on, and the order changed the time.
Oh, okay.
So the order said 5 o'clock on Sunday, for instance, to 5 o'clock Friday to 5 o'clock on Sunday was Dad's visitation. Well, they'd never done that. They'd had 7 o'clock and 7 o'clock, and then all of a sudden Dad starts being there at 5 or whatever the case may be. They went back to the original order, and the other party comes in, and I'm mad. I'm going to show cause him. Like, unfortunately, he's doing what the order says. So you got to read the order. Make sure you understand the order. Even after you get an order, it's good for you to sit down with your attorney and say, hey, let's make sure I understand this order. Make sure I understand the terms of it.
Well, and where the order came from. And I don't mean, like, that sounds kind of funny, but which court entered the order and which court continues to have jurisdiction to enforce the order. We see this sometimes in the juvenile court. Typically, it's just going to go back to the same juvenile court judge. So where we see this get a little confusing is sometimes in a divorce. You'll address custody, visitation, and support in the divorce, but then the divorce judge and the order will send those juvenile court matters back to the juvenile court to enforce or to modify any of the terms regarding support, custody, and visitation. So not only do you need to know what your order requires, but you need to know where you're supposed to go back to enforce whatever thing is not being done right per the order.
Yeah, it's very important because you wouldn't believe how many times people get this wrong and go to the wrong courthouse. And they have the case, and they've spent all this money preparing, and they go into court, and the judge's like, I don't have jurisdiction over this matter. And that's it.
And it's gone. The court can't sua sponte, which means from its own bench decide to take jurisdiction. It either has it or it doesn't. You can't create jurisdiction. But Scott, you mentioned a key phrase a few minutes ago. You said show cause. What is a show cause?
Yeah, it's so weird. When I remember first practicing, I don't know why it just didn't click with me, even though I went to law school. It really means to show cause why you're not doing what you're supposed to do. So the order is, for me, I file a show cause against Jackie for her to show a reason, show a cause why she's not following the order. And quite frankly, most of the time it comes down to willful disobedience of an order.
Well, but wait, you're filing something that says that I am basically guilty of not doing what the order says, and now I have to show up in court with this, what sounds like an assumption that I've done what you've accused me of by not following the order?
It does, but when you go to court, that other side who's filed is going to have to show and demonstrate in that court and say, okay, here's what they haven't done, Judge. He was supposed to pay support at $300 a month for the last 6 months in our bank account. Here's our receipts. We've gotten $250.
Well, and I mean, importantly, though, most of the time you have to swear through an affidavit, at least in the circuit court.
Yeah.
You have to swear. It has to be a verified petition, which means you're signing it under oath that these allegations are true. And then you get Scott swore, and then I would get the summons, and I'd have to appear in court, and I would have to explain myself. Well, Judge, I didn't pay Scott $500 a month because I simply didn't have the money to pay. And then the next question is going to be, well, how much did you pay him? If I paid zero, it's going to be a problem. If I say, well, Judge, I paid him $403 one month and $322 one month, and here's why. Here are my bank statements. I gave everything I had. Those are the things that, and we're talking more about defense and the procedure, but if you need an order enforced, you've got to take these steps, figure out what's being ordered of you or of the other person, figure out what court you need to be in, and then you've got the case. Then you've got to put on the case. Well, what if you win? So then what?
Well, then what? The judge will enter an order. One of the things we didn't talk about is he'll enter another order. But there's two kinds of show causes. There's a civil show cause, which requires a civil penalty. There's kind of a quasi show cause, and then there's the total criminal penalty. But most judges more appreciate the civil penalty, quite frankly, than the criminal show cause.
Who gets to pick which one is filed?
We do. Your attorney will help you pick which is best. Usually criminal show causes are much more effective in cases of money because the idea is if they're not paying, the judge will say, well, you're going to sit in jail until you pay. And so that may be an hour, that may be 15 minutes, that may be 6 days, but you owe this person $700, you haven't paid them, and I'm going to hold you in contempt of court in the jail until you pay the purge, it's called. And if you pay that purge amount, you get out. It's like a get out of jail free card, but it's not free.
It's definitely not free. And we'll see in the circuit court too, maybe the person was ordered to pay, $2,000 a month. Maybe it was temporary support, and they didn't pay anything. And here we are 5 months later. By my math, that's $10,000. And we file the show cause, and the person shows up, and the judge says, okay, what's the deal? Why haven't you paid anything? And the defense is either going to be, I did, Judge, and she's lying to you, or he's lying to you, or it's going to be, I didn't have it, and here's why. And an attorney like myself or Scott, we're going to have already subpoenaed and asked for all the bank statements and the credit card statements, and we're going to look for where the money is being spent. We're going to look and see how many times you've been out to eat and been to Starbucks. And because if you've paid nothing, there's almost always a way to show that you could have paid something.
I remember a judge I used to do thousands of these cases a year when I was, not thousands a year, but thousands over the time I worked in juvenile court down in Richmond. And I remember one of the judges used to always say, I can pay that amount with a paper route a couple days a week. What are you doing? And so the implication was there's absolutely zero reason to pay zero, usually.
Right.
And so, like Jackie's saying, if we're defending you, the best thing you can do is pay as much as you can, and then we can make a good argument for that's as much as you can do. But if you're saying that's as much as you can and you're making a $600 BMW payment, I don't know. And again, it's willfulness. Were you willfully disobeying an order? What was your issue there? Why were you not paying? Why were you not paying the money you owed? Why were you not showing up for visitation? And we'll shift to visitation real quick. These things matter to you, so it's important that you share why it matters. For instance, say the order says that the child has to be returned at 7:15 every day in the morning, or when they're returned at 7:15. The reason for that may be that mom is, sorry, we're getting a little backfeed. I'm just trying to figure it out. But anyways, the reason being mom maybe have to be at work at 8 and has to drop the kid off at daycare and do all these things. So that's important. If he's 10 minutes late in that situation, that could put mom late for work or any other thing. So it becomes important. A lot of people say, well, I've only been 15 minutes late. I was only 5 minutes late. Well, depending on the circumstances, that may or may not matter.
Right.
Same thing with money. If it's an order for $315 and he's paying $310, that may not matter. But if that $315 is the only $315 mom or dad is getting,
right,
that $5 matters. And so we don't look at it as automatically it doesn't matter, it's only $5. We look at it in your circumstances, try to figure out how it affects the other person if we're defending you, or how it's important to you if we're filing a show cause on your behalf.
Well, and we both have done both sides, right? We've had the clients that come to us and say, well, this person was supposed to list the real property for sale by the date certain and it's not done, so now we need to file an enforcement action. And we've been on the other side where maybe we represent the spouse or the other party who wasn't following the order. But aside from money and maybe jailing, Scott, are there other remedies? Like in my example with real estate, let's say the spouse was required to hire an agent and list the property by June 1. It's June 5, June 15, maybe September 1, right? Still not listed for sale. And you go in for the show cause. What's the remedy for the court to say, okay, show cause, and the person says, well, I haven't listed it. Here's my 10 reasons why. Doesn't matter. I still haven't. What is the remedy at that point?
The judge may order you out of the sale position and put it in the other parties to sell it immediately. He may order a special commissioner to have property sold immediately. There's lots of the realities and the remedies can be creative as the judge wants to be, and whatever basically needs to happen to get that condition met.
Right.
So I don't even want to say these are the list because there's just on your individual circumstances can make a huge difference on what the best remedy is.
Sure.
And again, I just think people don't realize what the court's looking at is, the guy who has $2 million sitting in a bank and he refuses to pay the person $300. That's kind of where you get into like the jailable territory. Why is he not doing it other than just to thumb his nose at the court? And the court's going to be like, you didn't think my order meant anything? Did you not think that I have power to do anything to you? That's when the court kind of likes these criminal show causes, which make jail part of the enforcement.
Well, in our judges, I'm sure most jurisdictions have judges that are similar. They put it in an order because that's what they want done. And when someone comes in a willfully contumacious, you're going to see that in probably a show cause by either by your attorney or by the other side, willful contumacious behavior. It means you're on purpose not following this order. You don't have a real good excuse, is what that really means. And when a judge agrees with that is when you see the ire of the judge. I had a case with a judge here in the Richmond area who explained to my client and the other party, we were there trying to enforce an order and the other party was trying to defend their non-compliance. And he explained to the parties that he had a guy in front of him who had plenty of money to pay and just had not paid, exactly what Scott's describing. And he said, you would be surprised how quickly that money became available once I put him in jail. And he went on to tell us that it was not even 2 hours before that money was in the other party's hands. So it is a helpful tool. It does happen. You can be jailed for failure to obey a court order. It's kind of like contempt that you see on TV shows, except it's not somebody, screaming in court, but it's still a disobedient act and failure to follow a court order. So you can be jailed.
Orders matter to the court.
And you can be ordered to pay the other attorney's fees as well.
Oh, that's a big one. Can you imagine going to court because you went to thumb your nose at the court and she hires a lawyer? The lawyer charges her $10,000 to enforce that case, and then what was $200 is now $1,200 or $12,000 you're having to pay. Makes a difference. You got to think through those things. It's never a good idea just to thumb your nose at the court for no reason. I realize sometimes there's valid reasons in people's minds, but it's really important to know the facts. And when we talk about these things, these podcasts, we're really talking generalizations on purpose, because there's even a quasi-enforcement kind of thing, a quasi-civil, quasi-criminal enforcement piece. But your case, your specific case, and your options are going to be best decided here when you come talk to us and sit down and when you lay out everything that's going on. We look at your order. So that's what you need to do. We highly suggest that.
All right. Big 3 takeaways from the what to do when you need to enforce an order.
Number 1, know your order.
And number 2, know which court has jurisdiction over your matter.
And 3, know your options. What are your options? Civil, criminal, enforcement. Maybe it's a negotiation even. There's sometimes a simple phone call can get this thing settled.
And included in your options are the remedies. What are you needing to have done as a result of? Maybe you're successful, but the options include what remedies are available to you.
And remember, when you're trying to enforce an order, quite often attorney's fees are available to you.
Well, we appreciate you tuning into our podcast today. Be sure and like and subscribe wherever you listen to your podcast. We look forward to seeing you next time.
Blessings. Bye.
We hope you've enjoyed this episode of What to Do When. For more episodes, be sure to subscribe to our podcast, and we encourage you to check our archives to listen to previous topics. Tune in next week for a new episode and some fresh perspective from Critzer, Cardani.